So I'm Tim Crosland. I'm a lawyer, a barrister with the charity Plan B. That's climate litigation. We're taking action against the government. I'm also a legal advisor to Extinction Rebellion. But this is the context of the Heathrow pause, something quite separate. People have already got a written legal briefing that's out there. I'd really encourage people to read that. That's where the detail of different offences is set out. The purpose of this vlog is something a little bit different, just to give people an overall sense of some of the key high-level principles. And the first thing to say from a legal perspective is that law does not operate in a vacuum. There's not a single answer to what's going to happen here. Law operates in the context of the media, politics, and the situation here is unprecedented in all kinds of ways. The context of the climate emergency, which is so disorientating for everybody. The way that the public, the politicians, the media might respond to a successful pause action. And that just means there is some inherent uncertainty about what's going to happen and how this will all land. I'd just like to start with a quote from Professor Jim Hansen, the godfather of climate science and someone who himself has taken to civil disobedience for the cause of the planet. And this is something that he had to say, and he said it particularly directed to people in Britain. It's not for me to determine what is the best course of action for any one of you. I point out here only that every major personal choice of necessity must, or at least should be, preceded by a personal assessment of available resources, opportunities, trade-offs and risk. In particular, I urge every young person to consider the full range of likely consequences before undertaking any major act of civil protest. And if you elect to proceed, I urge you to carry yourself always with dignity, that by your example you should serve as a light in this dark time. And in many ways that is the context for this legal briefing. The decision has got to be a decision of conscience for individuals. It's not a technical decision. It's not a decision anybody else can tell you what to do. It's your own personal decision, guided by some information about the legal risks. Just like to distinguish between what the law really says and the way the law is likely to be interpreted. We have in the common law something called the doctrine of necessity. We've got old cases from the Fire of London, and the essence of those is to say, normally it's a crime to break a window. You break a window because your neighbour's house is on fire and you need to get their child out, or you need to get your neighbour out. That is not a crime. It's a basic principle of law. It's a basic principle of morality. It's there in our common law. And I'd ask people to think about that and think about the relationship between a true law and moral principles. What we're seeing already in reality in the magistrates' courts is people are running this argument. That argument is being rejected, in particular by magistrates. It's been successful in the Crown Court. It was successful in the context of an act of civil disobedience outside King's College, and there the verdict was returned by 12 ordinary women and men, a jury, and they acquitted 2 rebels in large part on the basis of this defence of necessity. And that presents the authorities with a dilemma, because if people are charged with a serious offence arising out of this action, that becomes much more likely you're going to be tried by a jury. And we know that a large proportion of the public accepts that we're now in a time of climate emergency. And so the conventional wisdom is that your prospects are much better before a jury than before a magistrate's court. There's been some talk about terrorism in the context of this action. I'd just like to put that into context from a legal perspective. The legislation is very clear. Terrorist act offences apply where an action creates a serious risk to the health or safety of the public or a section of the public. And in my judgment, it would be very difficult to square that legislation with an action where small drones are being flown at head height, not in a flight path. Because the reality is that that action is not putting the public at risk. Doesn't mean to say people won't try and apply it, but in my opinion, the risk of that is extremely low. There are various legal offences around flying drones within a 5-kilometre radius of the airport. Those are relatively low-level offences, potentially punishable with a fine, community service order. And then in the middle range, there's the potential for a charge of public nuisance. That is the charge that was brought against the FRAC-free 3, who were originally sentenced to imprisonment. Those sentences were later quashed. It was suggested to the Court of Appeal that sentences of imprisonment would never be appropriate for people taking non-violent action of civil disobedience, conscientious action. The Court of Appeal didn't agree with that. They didn't say imprisonment will never be appropriate. They said it is generally not what the courts do for acts of conscience. So that is some context. But it's important to be prepared for a situation that is quite different from other acts. This is a more significant act. That economic disruption is potentially much more substantial to anything we've ever seen before in this country. That's partly the point. And you can see how a media backlash, a public backlash, could potentially feed into the courts. And there could be a risk of substantial sentences of imprisonment for a public nuisance offence. And it is better from the point of view of any individual taking this action to be prepared emotionally and practically, you yourself and your families. Just be prepared for whatever comes at you. That's part of taking an action of conscience on this scale. And I'd just like to close with a quote from Martin Luther King, written himself from Birmingham jail, called Letter from Birmingham Jail. There are two types of laws, just and unjust. I would be the first to advocate obeying just laws. One has not only a legal but a moral responsibility to obey just laws. Conversely, one has a moral responsibility to disobey unjust laws. I would agree with St. Augustine that an unjust law is no law at all. Now, what is the difference between the two? How does one determine whether a law is just or unjust? A just law is a man-made code that squares with the moral law. An unjust law is a code that is out of harmony with the moral law. To put it in the terms of St. Thomas Aquinas, an unjust law is a human law that is not rooted in eternal law and natural law. Any law that uplifts human personality is just. Any law that degrades human personality is unjust. So not traditional legal advice, but an important idea, important thoughts for people contemplating acts of conscience. So thank you and good luck.